Possible reasons for motions to dismiss in debt law cases. Brought to you by YourLegalLegUp.com, your advantage if you are being sued by debt collectors. We've discussed motions to dismiss in many ways in several videos, but we've not ever simply listed some of the most common possible bases for dismissal of debt law cases. In this video, we're going to do that, taking them in a sort of chronological order. Note before we start that you must consider your own case on its own facts and draw your own conclusions about whether a motion to dismiss on any basis is appropriate for you. That's a strategy question that only you can answer. I'm pretty sure you wouldn't want to do all of these motions, and you may not want to do any of them. There are times when allowing the case to proceed either directly to discovery or trial without a motion at all will suit you best. Although in general, we like the strategy of making motions if you can. We do that because a successful motion is a fast way out of the case and safe. It's the safest way, and even an unsuccessful motion adds to the difficulties of the debt collector. We're not recommending or any way suggesting that you file a bogus motion, however. That wastes everybody's time and will cause you to get on the judge's wrong side. That's not a good place to be. Therefore, before you do a motion, think carefully, do your research, and then if it makes sense, file it. On what basis might you file a motion to dismiss? There are two general categories of motions to dismiss. Either there's something wrong with the case as it pertains to you, and in general these motions have to be brought before you file an answer, or there's something wrong with the case as it pertains to the court or the law in general. We'll address each one in turn. The first basis of a motion to dismiss would be something jurisdictional as it applies to you. For example, they didn't serve you, but you found out that they said they did. That's called sewer service, and the basis for the motion to dismiss would be that the court cannot properly exercise jurisdiction over you without proper services of the suit. If you do something besides file a motion attacking jurisdiction on that basis, you'll be waiving that basis of attack and consenting to the court's jurisdiction. And in general, it might not be one you want to waive unless you happen to be represented by a good lawyer. Then you might want to attack without waiting for the other side to fix it. Another basis for a motion to dismiss might be based on the Fair Debt Collection Practices Act, the FDCPA. As we've discussed before, one of the rights of the FDCPA is to require verification, or it could be called validation sometimes. If you exercise that right and the debt collector files suit after that, but before verifying, that would be a basis for filing a motion to dismiss and also for a counterclaim. The FDCPA also requires that a debt suit be brought in one of two places: where the defendant was when the contract was created, or where the defendant currently lives. Suit in the wrong jurisdiction not only violates the FDCPA in terms of counterclaims, but also might be the basis for a motion to dismiss. Filing something else first might, and probably does, waive the right to move to dismiss on these bases. Another type of motion that should be brought before answering the petition or complaint would be based on the wording of the petition. If the petition is sloppily or unclearly stated, you might file a motion to dismiss for being confusing. You might also want to file what's called a motion for more definite statement in the alternative, since some courts don't like to dismiss a case on the basis of confusion. If your rules of civil procedure, you should look to see all the bases for motions to dismiss and whether they must be filed before answering or not. Filing an answer before the motion to dismiss might consent to whatever was wrong and waive your right to move to dismiss. The other type of motion has more to do with the lawsuit itself than with either you or the pleading. If the plaintiff is a debt collector and not on the debt contract and does not allege facts showing its ownership, you could file a motion to dismiss for lack of the proper party and interest being present. I like the idea of doing discovery and then filing a motion for summary judgment on the same basis rather than a motion to dismiss, after you can prove they can't prove ownership. Or suppose they make you the defendant because the proper defendant has your name, but it isn't really you. That could be a motion to dismiss that you could bring at any time. Or similarly, if the basis of the claim is illegal. For example, suppose you promise to pay a mob hitman for a job and then refuse to pay. A lawsuit would probably be the least of your problems in that case, but if the hitman did bring suit, you could move to dismiss on the basis of the claim being against public policy and unenforceable. And of course, if the lawsuit were brought in a jurisdiction that's inappropriate for the suit, you could get it dismissed. You, for example, can bring a claim under the FDCPA in either the state or federal court. But most debt cases can only be brought in state court. Filing an answer wouldn't waive this basis for motion to dismiss. Statutes of limitation are a little bit odd. If the petition alleges all the facts necessary to show that the statute of limitations has run on your case, then you could file a motion to dismiss before answering. And you might actually need to. Now, that's rarely the case, however. Most statutes of limitations are established by facts that are not pleaded and would more likely be the basis of a motion for summary judgment. Again, your rules of civil procedure will tell you the legal basis for motions to dismiss and also when you need to bring the motion. I suggest that you find that rule and read it, as it may give you some ideas that could help you. Protect what's yours and don't let the debt collectors rip you off. Debt collection is a social justice issue. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help other people find our materials. YourLegalLegUp.com.